To begin the session, I'd just like to welcome everyone here today and thank you all for joining. So my name is Isabella and I am the Carer Education Officer here at Connecting Foster and Kinship Carers. And here with me today is Heather. She is our Senior Advocate. And I'd also like to welcome our guest speaker, Deanna Ryan, who is the Supervisor of Long-Term Guardianship Assessment Team. She's just giving us a wave. I don't know if you can see her. And I'd like to thank you, Deanna, for being here today and presenting on this topic for everyone. So I'd just like to begin with the acknowledgement of country. So we acknowledge that the land we meet on is the traditional lands of the Kaurna people, and we respect their spiritual relationship with their country. We acknowledge the Kaurna people as the traditional custodians of the Greater Adelaide region and that their cultural beliefs remain important to the Kaurna people today. So I'm just going to do a little bit of an outline for today's session and what it's going to look like so everyone is on the same page and everyone knows what we're doing. So for this main part of the session, I'm just going to ask if everyone can remain on mute, just so there's no sound interruptions or connection issues. We are filming this session today so that carers that couldn't make it in the session today can watch it later, and also people in the regional areas. So by having everyone on mute, it's just going to keep it a bit smoother and the sound coming through will be a bit clearer. So Deanna has received the questions that you guys sent through. So she's going to be answering them throughout the session and also at the end of the session. But if you guys have any more questions that pop up during the session or you need clarity on something, there is the chat function at the bottom where if you could ask the questions through that function, I'll be able to keep an eye on them and read them out at the end when we do a bit of a Q&A. So feel free to write any questions in there throughout the session if they pop up in your head. And if we don't address them straight away, we can get to them at the end. And also, if you don't get the chance to ask a question or it's a bit more of a personal question, please just email us later or email me to my email address and I can follow up on your behalf with Deanna. So it's a bit more private, just if you don't want to ask in front of everyone here today. But that's basically everything. So I'm going to pass over to Deanna now to start the session. Thanks so much, Deanna.
Thanks, Isabella. Hello, everyone. A couple of familiar faces. Can everyone hear me okay? Bit of a thumb up? Yeah, beautiful. Right, so I have received all your questions. So what I'll do is similar to what we did last November. Was anyone, I can't see everyone's faces, but I assume some of you were at that session in November last year where I came in person. So as we did back then, we'll just sort of skim over a little bit of the whole process, and then I will focus on some of the key areas that I think some of your questions sort of fitted into. So the way I'm looking, I've actually got in our big conference room, so I've got a big screen on this side and obviously the camera here. So I'll sort of flick between the two. I find it weird looking at the camera. So if I'm ever looking away where I am now, it's actually looking at all your faces. So it might come across a bit weird, but we're going to run with this beautiful technological world that we're in at the moment. So if there's any questions that I can't answer, we'll car park them, and Isabella and I will do our best to answer them at the end. I would also extend an invitation for you to contact me directly if you wish to talk about anything LTG. So I will, Isabella's got my email address, and I'll make sure that you all have my phone number too that you can ring through if you have any direct personal questions you want to ask around LTG. So what I'll do is I will go through the full process, and so we'll start with the legislation, which is what LTG fits under. So in the 2017 legislation that surpassed the 93 Children's Protection Act,
there was some slight change in language and a little bit of change around the legalities and processes of LTG, which was formerly known as OPG, other person guardianship. So with that shift came just some policy changes and some procedural changes to make sure that we're meeting our legislative requirements and to make sure that everyone has a pathway to get to long-term guardianship or OPG. I'll use those terms interchangeably, and that way you'll know that I'm actually talking about the same thing. So with the new legislation came in, under Section 89, there was provisions for approved carers to actually submit an application directly to the department. And if they needed to, they could actually surpass the office that they're allocated to, particularly when OPG or LTG had been talked about for a long time, but there was limited traction in terms of formalising it. So the other thing, the reason why an application was formalised from the expression of interest, which it was previously, is to ensure that legislatively we're making sure that the carers and prospective guardians were aware that when they apply for LTG, they would then become unprescribed to the department under Section 89 to 91. Under Section 53(1)H, it allows DCP to apply to the court for the guardianship of a specified person. If we, the department, go to court just under 53(1)H, it means that the child remains prescribed to the department. So the department still holds on to responsibility for case management and making sure that the child's needs are being met. Within LTG, specified person under Section 89 to 91 means that with an application, kicks off a full assessment to make sure that the prospective guardians have the capacity to provide the same level of care to the children without DCP involvement. And that means that they become unprescribed to the department, whereas the others are prescribed. I think I actually got that the wrong way around when I said it earlier. So under Section 53(1)H, they remain prescribed to the department. If they go through Section 89 to 91, it means that they are unprescribed, which means they are independent from the department, and the department no longer has case management or legal responsibilities over the child. So hopefully that makes sense in terms of the legalities and legislation. So once an application has been submitted, that can be submitted directly from the proposed guardian to the department, or it can be submitted by a third party. So that might be your allocated worker can submit it on your behalf. That kicks off an assessment. So our assessment process is broken into two spaces, and it's phase 1 and then phase 2. So phase 1 is actually undertaken in the allocated office that you're attached to. So I would, upon receipt of your application, I would send a letter of receipt directly to you as the prospective guardian, and then I also send an email to the allocated worker and office to say, we've received an application, you may or may not be aware, you need to kick off a phase 1. So they have a full procedure that they need to go through to meet the requirements of that. That would be conversing with the birth parents to ascertain their views of the transfer of guardianship to the approved carers. They may or may not consent, and either way, we will document their views and move forward. If they oppose the application, that does not mean that the LTG process stops. It means that we document and move forward. So we then have conversations, obviously, with you as the proposed guardians. We would have conversations with the children if they're age and developmentally appropriate, and we would then make sure that all of our case management, in terms of departmental case management, is up to date. So we make sure that we've got birth certificates on file and uploaded to our case management system. We make sure that we've got the original copies of the initial long-term guardianship order. We make sure that it's home safety check, case plans, genograms, everything is up to date on our system. At the end of phase 1, we will, the department will pull together a phase 1 outcome meeting. So that's attended by our principal social worker, so a PSW that's attached to the office. If it's a culturally appropriate matter, there may be a principal Aboriginal consultant in attendance. Or there might be some consultation with other cultural authorities, with being if it was a child from a culturally and linguistically diverse background. Where the carer will attend, the child, again, if it's appropriate, will attend, and the allocated worker and office supervisor. You will just make sure that the eligibilities all ticked off on the outcome meeting template. That you have a really robust conversation to summarise all of the capabilities that we look at within the LTG assessment, to make sure that there are documented and demonstrated capacity in that area. And that's all ticked off. Nice robust minutes of the meeting is also attached to the minutes outcome or the meeting outcome, and that's submitted to me with a referral for phase 2 if it's recommended for progressing through the process. If long-term guardianship is, if some issues are identified in that phase 1 space, what will happen is it might actually be not recommended initially, but if a non-recommendation comes through, that cohort of people will identify some goals and actions in moving forward to a place where LTG might be viable later on. And so if there's any of those carer competencies that aren't being met clearly, then they might, in the office space, might work with you to make sure that there's, that we're on, that we've met all of those capabilities in moving forward. And then later on, they'll have another catch-up meeting and they'll go, okay, great, we're ready to move on. The majority of referrals that I will get through are, very well documented. It might be a situation where I'll do a little triage of the referral and send an email to the office just saying, look, there's a couple of other things that need to be done, and I can get it ready for allocation for phase 2. So when I do receive a referral, we make sure it's all ready to move forward, with in mind that once we've finished our assessment and it is, if it is recommended for going to court, that departmentally we need all of our little case management ducks in a row. So we do a little QA, a quality assessment, as we go through to make sure that when we do hit court at the end, that we can close off the child's file and know that everything that's meant to be there is there. So I know a lot of you from your questions were really keen on talking about particularly phase 2. So what I will do is move on to phase 2 and what that actually looks like. Isabella, if you can see everyone's faces, if people are happy to move to specifically talk about the full assessment in phase 2, and if there's any car parked questions about phase 1, we can come back to them later. Is everyone happy to move on?
Yeah, everyone's got a thumbs up that I can see.
Yeah, fantastic. All right.
Perfect.
So once we, if you've done a phase 2 assessment or you're in one at the moment, you'll know that it is quite a comprehensive assessment. We go into a lot of detail because we do need to provide the court with a robust assessment report that looks at evidence-based behaviours and actions of the prospective guardians that actually shows the court that we are extremely confident that we are able to walk out of this child's life and have them live happily ever after. So it is quite intrusive, the assessment. We talk about your background, your upbringing, your attachment relationships throughout your lifetime and how that helps you form attachments with children that come into your care. And how we, develop our children to be able to continue on and form and maintain really healthy relationships through their lifetime. Considering that the majority of our children do have, you know, sometimes quite extensive trauma histories. So, and that can be displayed in behaviour and obviously some of their development as well. So it is quite intrusive. We're also very, you know, aware that it is quite sensitive information. So, you know, we won't delve into the you know, the real challenges of your life too much. But we do need to make sure that you yourselves don't have any unresolved trauma and issues of your own that may impact your ability to care for the child in future. So it is really child focused. It's all about meeting the child's needs, not only now but into the future. And you know, most often than not, we're looking at LTG being a lifelong commitment, albeit not legally, because the order does cease at 18 years of age, but emotionally and those relationships are often forever. So we will make contact with the prospective guardians. We'll make a time to come out and have a chat to make sure that you understand what the assessment's going to involve, and also, you know, what your expectations are, what our expectations are, and obviously, you know, our legal responsibilities to make sure that we get everything done. At the early stages of phase 2, you'll be given some medical forms. So one of them is a medical self-assessment, and also a little form that you need to take to your GP to get basically the tick off to say that there are no health issues that are going to impact your capacity to care for the children, you know, in the foreseeable future. Obviously, we don't have a crystal ball, and we can't look at, you know, years into the future, but just making sure that you're healthy enough to be able to provide independent care of the children. At that point in time, yeah, actually in phase 1, I will take a little step back and say that the financials are always a big topic of discussion, and they do need to be concreted by the end of phase 1. So our policy enables our prospective guardians to receive the basic subsidy for the duration of the order, a special needs loading if a loading is in place at the time of going to court. And if there's any agreed private schooling fees that are in place, the department will honour those agreements. And also therapies, obviously above and beyond NDIS, and you know, community accessibility. So if you've already got those in place, you can discuss that with the office, and that will automatically come over into your financial agreement into LTG. There are case by case, there would be other incidentals, you know, other requirements for a child. You know, it might be something like swimming lessons, you know, if a child's got some lung issues and swimming lesson is actually physically therapeutic for the child. That might be something that you can discuss with the office. What we say in those instances is if there's anything above and beyond the policy financials, that you and the office prepare a financial agreement or proposal and send that up to the executive director for approval and sign off. And if that's done, that needs to come over obviously to phase 2. And we don't have any delegation, my team and myself, around finances. So if anything above policy has been approved by obviously a regional director, then no questions asked, I'll just bring it across into the long-term care plan at the end of our process. I think that covers most of the questions around financials. What did get included in the May upgrade of our or review of our policy is that a formal annual financial review will occur with all of our LTG families to ensure that you know, the needs of the child's being met, that, you know, schooling, you know, all of those payments are still going through. Obviously, if it is school fees that we're covering, we'll need to do an annual request for those funds through our department. and all of those additional funds besides the basic subsidy are subject to that annual financial review.
So we've just got a question pop up, and someone asked, who does the annual financial review?
Yeah, so that responsibility goes back to the allocated office after the long-term guardianship order is granted. So, and that's, it's, you know, even though it was last May, it is still a fairly early it's an early days process. So there is still some work being undertaken within the department to make sure that there's some consistency statewide around what that process looks like. Because we need to keep in mind that, you know, case management is no longer a part of LTG. So, you know, so that is still in the, I guess, the clarification sort of stage, and making sure that we're really meeting statewide consistency in that space. So I will advise anyone that's going through phase 1 or 2, we will keep them updated with any finalities in that space. Yep. All right, hopefully, Kimberly, that answered your question for now, and we can go back to that later. Obviously, down the track, there might be some more clarity coming in that space, but at the moment, and for the foreseeable future, it does sit with the allocated office. Now, it might not be your allocated worker that you've got now, but there will be someone that's allocated it for administrative purposes to watch over the financials. All right, I'm just having a little look at my list of questions, if you don't mind, and put my little glasses on. So again, is there ongoing support for trauma-related needs? So yes, that'll be discussed at the annual review, and any applications will be within departmental scope will be obviously subject to the financial review and approval processes. I think I've talked about the other. So the question, I had a question around whether the financial management plan is based on what you've received in the past. So no, what it will do is it will look at what's in the policy and what's the requirements of the children or child now, and then it will be reviewed future. So some of the other things like extracurricular activities are not included in the policy. So everything that they might be supported for financially, unless it's covered in the policy, will need to go up for approval through the regional director in LTG World.
I just got another question pop up. It's, does the financial review mean that financial support can change as the child grows?
Yes, that is the understanding of what that process is. You know, a child's needs may increase, a child's needs may decrease over age, and that the purpose of that annual review is to look at that space in time and that foreseeable 12 months, and then obviously check that yearly as the child grows. Yeah. All right, so the other thing to consider is whilst the financials and the order and everything sort of finalises at 18 in terms of the agreement that's in place now, the department does have a stability in family-based care program that enables the carer payments to continue post 18 years. And that's a process you can apply as the child ages towards 18, and that can be put in place. A little assessment occurs, and Nicole Wellman is the supervisor of the Stability and Family-Based Care Program, and she'll be able to go into a lot more detail of that, particularly if you've got a child that's sort of reaching into the adolescent, sort of mid-adolescent stage, and looking at sort of moving towards that 18 years. So you can absolutely have a conversation with her. And there's also, Isabella, I sent you a link that's a publicly available document, which is a Stability and Family-Based Care fact sheet. So if you're most welcome. It's just a public link that I've sent through to you. So feel free to share that through to your carers.
Yeah, I can send that out.
Yeah, fabulous. And equally, if you go into Google and type in stability and family-based care, that will come up in your browser. So I guess the assessment itself, if you have a look, I've obviously got a step-by-step competencies list in front of me, but again, that's available on the DCP website. If you go into long-term guardianship, you can link into all of these. And it's also, the competencies are also on the back page of your application for LTG. So you'll be able to see what's required of you and what we'll talk about in terms of the assessment itself. So we talk about attitudes and connections. So we'll be looking at what your motivation is for LTG, what your support networks look like, financial resources. So that's, you know, ensuring that despite the support you get from the department, that you're financially stable enough to maintain your accommodation and things like that. Cultural respect and understanding. And we look at culture as quite holistic. So it's not just about nationality and origins. It's around, you know, the child themselves. You know, if you can imagine a fish immersed in water, culture surrounds us. So what is the culture of your family? What is the culture of the family that the child has come from? And how do we support the dual identity of children, or how do you support the dual identity of children as they grow and develop into adults? We also look at attitudes towards birth family, and we'll unpack what, you know, what complications are occurring in that space, and how you manage to, you know, maintain an unbiased and sort of neutral stance, but also obviously being protective of the children at the same time. We look at personal resilience, so we look at your trauma and grief and your capacity to overcome trauma and grief, and that's obviously something that will cross over into the life of the child. So we look at your capacity of dealing with stress, you know, life stresses as well as kids' stresses, and the combination of the above. So that's really important for us to unpack as well. Your relationship fertility is another thing that we talk about, to make sure that, again, there's no unresolved grief and trauma in that space, because, you know, it's a big part of our lives as, you know, as nurturing people, and so we'll talk a little bit about that too, to make sure that, you know, again, with the motivation of caring, making sure that there's no big conflicts in sort of that, in that space. We look at child-focused nurture, so, you know, how you provide nurturing care, and that's the part where we can take a lot of observations and evidence from our documented case notes on our system, where, you know, you'd probably be involved in a lot of departmental workers, and they'll document all the great things that are going on in that space. So we'll make sure that that's covered as well. And then working with others, obviously, you know, once you've got DCP, you know, independent of DCP, what's your capacity like to, you know, approach other professionals and, you know, other, you know, mental health care plans and things like that, without any support to ensure that you've got enough supports around you to be able to move forward. They're the key competencies that we actually look at, and when you do get to the end of your assessment, we'll give you the assessment report, complete transparency about what we've included in the report, and also what, you know, what your views are. So everything that's in the report is based on the perspective of the carers and the children. So your voice is very, you know, heavy within the report. Your concerns are documented, as well as, you know, your dreams for the future of yourself and the children. So it's heavily weighed on the on your views and your voice. We'll also bring in third-party evidence, which might be, you know, referee checks, might be departmental documentation that validates your views and your perspective, which, you know, is very important when we're in the court space. So at the end of that assessment, we'll obviously get you to have a read through the report and elicit some feedback from you, making sure it's accurate, because obviously we're, you know, crazy note taking while we're having face-to-face conversations. There might be times where we reading through what our notes are looking like and what our reports are looking like, and we think, oh, there might be a little bit of gap in this space. We might send you a worksheet rather than a face-to-face conversation and just say, look, here's some really pointed questions. Can you give us you know, a sense of where you're at in that space? So we'll sort of combine that face-to-face and written you know, responses to questions, and that to make sure that our assessment report's really robust and meets the requirements of court. With the actual assessment report itself does not go to court, that unless it's subpoenaed. In the 2.5 years that I've been in this position, I haven't known one court case to be subpoenaing your assessment report. So once that's completed and signed off by executive to proceed to court, we'll upload it to our case management system under the carer's profile, and that's where it stays. So let me think. I don't think there was any other big questions within that space. I think a lot of it sat within the next area, which was really common around your questions, was contact, family contact. So I think I'll spend a little minute talking about that, if that's okay. So contact isn't something that we just talk about in one section. You know, contact between children and their birth families is something that occurs right throughout a child's experience in care. So phase one, we will look at the department and the office will look at what's happening in the space of family contact. So they'll look at, you know, does family contact occur at all? If it doesn't occur, why? We make sure that there are, you know, some really clear rationales as to why it's not appropriate for contact to occur, and in some instances that is the case. And if that's the case, we move forward. We know what we need to know, and we can move forward from there. Sometimes it might be that, you know, some of our birth parents are sort of out of the picture, you know, for a time, and that might be over the course of years or months. And, you know, there are some occasions where it might be sort of six years or so where a parent might have been, you know, not in contact with their child. Because we don't sever parental rights in Australia or South Australia, they do remain a party to the proceedings of LTG. So we have an obligation to seek their views of LTG and also have them to be part of the court process. So when we do either phase one or phase two have some conversations with our birth parents in that space, it can raise some concern with our parents. It can open up old wounds that they've experienced previously when the child's come into care. And so quite often, even if contact hasn't been occurring, it kind of, you know, albeit sometimes it's momentary, sometimes it's ongoing, but it really gets them to a point of wanting to, you know, reconnect in that space. From my experience, most often for the fear of never seeing their child again once the department's no longer involved. So sometimes that does refresh their requests for contact. And if that does occur and it's appropriate for the child, if the child's old enough to express their wishes, we take on board their voice. We look at, you know, in terms of our assessment as a department, whether it's appropriate that they have contact. If they haven't had contact for a while, it might mean that the department will help facilitate some, you know, letters being shared with each other and photos and things like that. So starting off really slowly. And it might be that if this is a new situation or a refreshed situation, that the department does stay involved for a little while, but that will not stop the progression of the LTG order going through. It just means that we might put in the care plan at the end that the department will continue and review this in 12 months with the view of handing over contact with the guardians at a time that's appropriate. I had a question around contact of whether, you know, if parents stop attending contact, quite often when the department is involved, with a child, and we're facilitating contact. If parents don't turn up, then sometimes we will reduce contact. When it comes to the long-term care plan, so at the end, contact arrangements will be in place in that document. I'll talk about that a little bit further down the track in terms of other elements of the long-term care plan. But if there is no contact, it will state that. It'll also state that if the child or parents wish to, in the future, facilitate some contact with each other, then the department will be contacted and we'll do an assessment to see what's in the best interest of the child. So we'll talk to the child, we'll talk to the guardians, and we'll make sure that whatever contact is commenced is in the best interest of the child. And so in the care plan, which will go to the parents and the guardians, we'll say that, you know, any future contact will be initially undertaken through the department, or at least assessed through the department. If contact's already occurring and there's an expectation that our guardians and birth parents communicate around, you know, ideally they will communicate as parties to the care plan, and make sure that everyone's wishes are respected and maintained in that space. So if there are some issues in contact or any other area of the care plan, then the dispute resolution can be undertaken if there's any conflict in that area. So Relationships Australia offer a mediation service, and so they can be contacted. There's also a stipulation in our policy that if mediation has been attempted but has been unsuccessful, then you can contact the department and request some support in ironing out the issue that you might have in place. In terms of contact arrangements, it's quite informal when it comes to LTG. So there is no court order stipulating how often contact needs to occur. However, you know, when we're looking at what's in the best interest of the child, even if contact's not occurring, then we need to be really open-minded about how that might look and what that might look like into the future. So I'm just thinking about some of the other questions about contact. So I'm just going to have a little look through. Someone asked around DCP involvement in terms of agency support. So, you know, whether the carer agency remains involved or whether DCP can remain involved. In some situations, DCP do remain involved just for the provisions of facilitating contact, particularly if there's real safety concerns in terms of, you know, unpredictable behaviour, and things like that. So there is some capacity for DCP to remain involved to facilitate contact. So just because contact can't occur between directly the guardian and the carer, the guardian and the parent, that does not stop LTG from going through. Okay. If you are linked to a carer agency, the direct support for that child under your guardianship ceases. So unless you have other children or will have other children that are not under your guardianship in your care into the future, then you won't have the ongoing support from DCP or the carer agency. Does that make sense? Yep. Okay. So given that, like I said before, DCP can remain involved for facilitating contact, but it 9 times out of 10 would be the responsibility of the guardian and the parents to work through that quite naturally. I'm just coming to flick through to make sure I'm answering everyone's questions. So I've talked about mediation. As someone said, if there's no biological contact, will the LTG worker need to be in contact to discuss LTG? The answer is yes. We do contact the birth parents even if they haven't seen them since infancy, because they remain parties to the order. Okay. I think that covered most of the questions. And again, if I haven't answered it clear enough, then type away to Isabella, or we can obviously, again, like I said, have a conversation at another time. I'm more than happy to unpack. It's really hard to look at the intricacies of individual cases and situations. I'm sort of looking at it as a whole. So if you want to talk about your specifics, then, you know, why not have a bit of a phone link with the office, myself and you know, yourselves as the carers, to unpack what that might look like.
So I've got another question. It's
Sure.
What happens if the biological parents can't be found or contacted?
So that's actually, you know, it is not uncommon in our space. So there's an expectation in phase 1 that they attempt to contact the birth parents. If they can't contact them, they will need to document all the different ways that they've tried to contact them. So there's an expectation that case managers will do a Centrelink check to get current addresses, current phone numbers. We've got the electoral roll, Medicare. We've got a memo of understanding between agencies that we can request updated information, contact details. So we've obviously done all those checks. They'll document that in the office space. We will take on board phase 2, so a bit of a tag team over to phase 2. And if we haven't had any luck yet, we will again do those checks. So we'll send out a registered mail. And so right along the process, we'll document the dates we've attempted, how we've attempted. And so long as we go to court with a really clear over a timeline attempts to contact, then the court is most often satisfied that we've made all the attempts possible. And if that's the case, then court in that instance will quite often then put the orders through without birth parents' involvement. So hopefully that answers your question.
I've just got another one here. She said, is there also a yearly case plan reviewed with DCP, guardians and biological parents? I think we talked about that a little bit earlier. I think she may have came in late.
Yeah, so obviously the annual financial review that occurs yearly, and the actual review of the, it says in the long-term care plan as the template, so it goes through with every final version, is that in any changes to the care plan must occur with both agreement of the guardian and the birth parent. So any big changes. Yeah, it's quite an informal process after it leaves the court space. And there is no formal review of the care plan itself. All right, so hopefully that answers the question around that. I think I've covered mostly around the family contact, so if it's all right, we'll continue to move through.
Sorry, I just had another question.
I knew something would pop up.
This one says, if a birth mother states a name of the birth father, but the male in question has refused a DNA test, will the child ever be able to find out who their father is?
Good question. We will, as a department, obviously we have an obligation to ascertain paternity of children if we don't know. So if there's a possible father that we've identified, then we will do our best to request them to go through a paternity process. It is up to them. We can't force them to within my space that I'm aware of. Sometimes we do have children that go through LTG that don't actually know paternity of their father. With that, obviously, like anyone who doesn't know their parent, there are some agencies and support services out there that do try and find unknown parents. But yeah, it won't stop an LTG from going through. Obviously, if the department becomes aware of anything into the future, then it would be documented and accessible by the children through freedom of information. But I know that if any within the space of my direct knowledge is that if there's ever been a father identified through our process, then we have put it on hold while we establish paternity and then move forward on a case-by-case situation.
Thanks for that, Deanna.
No worries.
I've just had another one pop up.
Right.
So what happens with contact with other family members, so grandparents and other extended family, where the bio parent has ongoing issues with their own family? Do we as guardians have the responsibility to work with them separately?
It's all around the best interest of the child and connections, that dual identity that we were talking about before. So, healthy connections, best connections possible with family members. So what we would like to see in LTG in an ideal world is for there to be a really natural situation where contact occurs. Granny might ring through or FaceTime, or, might see each other, around Christmas time or birthdays or Easter, special occasions, things like that. And there's no blanket rule, but what we do want to see in an ideal space for those children, if it's safe and in their best interest, is for a natural, connection with family as much as possible, with extended family. Yeah. Siblings is another. We have quite large group of sibling groups within our space at times, and they might be in other care settings. They might be with other family members. Some of them might be with birth parents, and so it's really case by case around. And hearing from the child who they want to see, how do we introduce them to new family members that they might not have met before? And again, DCP can support with that process. But yes, it would be the responsibility of the guardians to, if it's safe to do so, to facilitate that contact with the child.
Thanks, Deanna.
All right, no problem. So I'm just thinking around, there was some more questions around previous OPG assessments. So if someone has previously gone through an LTG or OPG assessment, say, or ever, or particularly in the last few years, which is not uncommon. A child might have come into their care a couple of years ago and wasn't at a point where they could go guardian. So what we do is we ensure that we pull as much transferable information from that initial report over into our new report. We'll update whether anything's changed in that space. A lot of when you look at the step-by-step criteria, a lot of your experiences historically, as growing up, that hasn't changed. As past tense, we pull that over. A lot of your parenting, strategies would be very transferable, so we'll pull them over. What we do in that space is really focus on the specific needs of the child that we're referring to in this application or future application for court, and any specific strategies or parenting or concerns, struggles, all of those things that you might have specific to that child subject to that application. And so we essentially fill the gaps of what we don't know to make sure that we have all of that evidenced information relevant to that child and move forward. So given that, it does decrease the time required for that full assessment, because a lot of the information we already know. And so it can be a lot more sort of directed around that child specifically. We've got a couple in that situation at the moment, and it does decrease the time significantly. There was a question around timeframes of LTG. So it's not uncommon for it to take between 6 to 12 months to go through the process. And there are some unplanned delays that can occur. So You know, phase 1 can get drawn out for, you know, for where there might be care concerns that come through. There might be, you know, a paternity matter that we need to work out. There might be some challenges around the contact, you know, making sure that the contact's all working well. So sometimes that can, you know, unplanned delays can occur. We find in our space, in terms of phase 2, you know, sometimes school holidays can put a stop in, you know, family holidays. And we're really flexible in our space in terms of, no worries, you let us know that you're not available for a couple of months or whatever it might be, or a few weeks, we'll work around that. Obviously, you know, sometimes if staff need leave as well, so, you know, they might be, have a holiday planned or some leave planned. I've learnt by experience, while it's sometimes, I guess, sounds okay to have the assessments reallocated to a different worker. It sounds quite appealing to sort of get it done. However, that can often draw it out longer than just waiting a few weeks until your assessor comes back. So there's, yeah, that can cause a bit of a delay too. So we often make sure that unless we have to, we don't reallocate assessments. Some other delays, sometimes we're waiting a fairly long time to get the carer medicals back, the self-assessment and the GP assessment. Obviously we give you the report to have a look through, and sometimes that comes back with, you know, some feedback, so we need to flesh out what that looks like and make sure that we, you know, can get it to a point where we've got sufficient information to go to court, but also you're pleased with the information and the accuracy of the report. And of course, once it goes to Crown, once it gets submitted to Crown to go to court, you know, a lot of it's out of our hands. So we're sort of at mercy of the court process at that point in time. Is there any questions, Isabella? I think I saw one pop up.
Yep, one did. It's a lot of information for carers to take in. Is there simply a flowchart for the LTG process that carers can access?
Yes, there is a flow chart. There's also a LTG or LTG brochure that you can get, and it's a public link, so I sent that through to Isabella. A lot of the workflow it talks out the workflow in that document. So again, if you Google LTG brochure, it comes up. But yes, it's a huge process. There's a lot of information, a lot of different areas that we need to consider in our space. So I'm not surprised that it can feel like it's quite overwhelming or overloading with information. Yeah.
Thank you, Deanna.
No
another question popped up. It says, how does a carer's care concern history impact the LTG process?
Yeah, so as part of phase 1, part of the meeting outcome agenda looks at any previous care concerns. So what we're looking at is any serious care concerns and what that means for the child in an ongoing situation. It might be several minor care concerns, and we would look at patterns of those behaviours and what it might be for a child. We'd look at care concerns relating to other children that we need to consider for the child subject of the application. So if there's any open care concerns, obviously that needs to be managed before it comes to me. And if any care concerns occur whilst we've got a phase 2 in progress, we'll just pop it on hold for the time being until that's addressed, and then we will progress when we've given, you know, we get the nod to continue and everything's in a space where we can proceed. It's just looking around what the context of the issues were, and, you know, whether it was the, you know, response of a carer in terms of disciplining or, you know, whatever it might have been. We just look at it, what it is, we take on board, and it might come up as what we call an orange light, where we just unpack it, put a rationale in and move forward.
So I've just got another private message coming through. It says, does having a chronic degenerative disease affect the LTG application, as it didn't seem to affect the initial foster care application? Why is a medical done? Is it to check if the disabled person manages their condition properly? I'm not sure of the purpose.
Yeah, it's really around whether issues are being monitored, whether they're being addressed, and whether, if it is a degenerative type situation, what we will talk about in that space is progression planning. So we would look at, okay, and in any family situation, if someone becomes ill or incapacitated, what might that look like in our family unit? So whilst there are no legal ways that we can, under LTG, that we can put like a will, for example, we can't put in there, in the event of my death, the child will go to my sister. However, we can informally have a plan in place should someone's health deteriorate to the point of not being able to provide care. Again, it comes down to, some legal terms as well, in terms of, who is the, informal carer if someone's ill, the attachments that are already in place. And so quite often that will happen quite naturally. DCP should not become involved in future, apart from any little disputes or any financial reviewing and etc. We as a department shouldn't become involved again unless there are care concerns that are come in as external notifications to the report line and then managed through the department. So a lot of, whilst you can't legally plan for someone taking over the care of the child, you can certainly have some informal plans in place, and that's what we do. It won't preclude you from LTG. We just make sure that you have some really concrete plans in place to be able to provide that ongoing care to the child within the family unit.
I've just got another question come through.
Yeah, I'll just get you to hold that for a minute, Isabella. I do know that previously we have had a situation where a guardian passed away, and a family member had been taking care of the child whilst she'd been ill, and it does get a little bit tricky in terms of carer payments, because the payments do actually go to that approved carer. So if the carer is deceased, the guardian is deceased, then carer payments will stop. So that will need to be considered in that space when you are talking about that planning for future. So it might be, you have a provision as a guardian to go back to the youth court and add another guardian to the order. There is a maximum of 2 guardians that can be put on a guardianship order. And if you are the sole guardian, you can go and get legal advice, and you can go through the youth court to apply to have an additional guardian put on the order. The likelihood of what happens at that point is that the youth court will probably request us to do an assessment of that proposed guardian, and then formally provide some sort of reporting in terms of what we know of that care arrangement. So there are ways to manage, formally manage that situation. If you are a sole guardian and you're going through this process, have a think about whether you want a secondary guardian attached to the order. It means that we would do a care approval process, and formally we would do two household assessments for the one application, and therefore both parties can be attached to the order. So that's another thing to consider. If there's two guardians, for example, a husband and wife or life partners that are both guardians, obviously if one gets ill and possibly becomes incapacitated or deceased, the other guardian will remain guardian, and then they also have an opportunity of adding a second guardian to the order. So there are ways around it, and more than happy to have some conversations about that.
That basically answered the next question,
Oh,
so that's
good.
all good.
Very good. All right. So I'm just conscious of time. We're doing okay. Okay, so I've done the previous. Oh, so someone asked about name change, whether a child's surname can be changed prior to or as part of the application. Yes, absolutely. So we have an internal process of name change, all of which involve an assessment around whether it's appropriate for a name change. That involves a conversation with the child, carers, birth parents, and a principal practitioner or social worker in terms of the appropriateness of the name change. That can then either get sent directly through from the CE to the birth, deaths and marriages, or it can actually come through on our application to youth court. So we would essentially have two requests for orders on our application. The name of change process does occur separately to our assessment. So what we will hopefully understand that a change of name is on the agenda and has been talked about. What we will ensure is that the office will take on the requirements of the name change reporting and assessment, and then we'll focus on phase 2, and we time it to the point where they are both ready to underpin one application to court. But it will be done by separate parties. The actual paperwork and process will be done separately.
Just adding on to that, there's a carer asking if they want to change their name after LTG, how do they apply for this?
Yeah,
so initially they only decided to informally change the child's surname at present time.
Yeah, so they can apply to the Chief Executive for a name change after LTG goes through. Yep. Yeah, and the same thing will occur. There'll be a little assessment undertaken, and the CE, there's 3 different pathways for a name change, but there's the 2 main ones for us is through the CE, who then directs birth, deaths and marriages, or through a court process. And it depends. It might be around, the differences are around, you know, whether you've got parent consent, you might have both parents consenting, and if that's the case, you can go straight to birth, deaths and marriages yourself. And as long as all parties are agreeing, you might have one parent that's consenting and one parent that's opposing. That can be managed through the department or court. Or you might have both parents opposing, depending on the situation, it can still get progressed through court. All right. I guess for me, just around name change, because it is a bit of a hot topic at the moment in terms of our space. When there's, I guess, a couple of complex sort of situations occurs with us if we've had a couple of situations recently where a case has been in court. We've done the first hearing, we're on to the second hearing, and I'll talk about court processes in a minute in terms of the process. But you know, for example, a child might be informally known as, you know, Jack Smith, but if that's different to his birth name. And so when the child meets their child rep, who is their legal representative in the court space, they might say, oh, okay, so what's your name? And the child says, you know, Jack Smith. And they look down and they've got, you know, Jack Gibson on their file, and they go, oh, okay, so, you know, what's that about? And sometimes a child rep may go into the court space and say, well, you know, my little client here wants to change their name. So, and dependent on their age and capacity, they will request that that order is put through. So sometimes, particularly most recently, we've had to have the court case adjourned for a couple of weeks, so DCP can then do a quick change of name process and then provide the court with, you know, the fact that it is, you know, appropriate for a name change, and that can then be done at that space. It's not ideal because once we get to court, you know, everyone's, you know, anxious for a happy ending and a quick process. So sometimes that can complicate things in that space.
I just had another 2 questions pop up just regarding name change.
Yep.
The first one was, are there grounds that are considered reasonable for a name change?
Are there grounds that do consider or not? What was the question, sorry?
It says, are there grounds that are considered reasonable for a name change?
Yeah, case by case situation. It might be that the child has, you know, is over. They usually look around sort of the 10 years plus, having a real voice in this space. You know, sometimes we have, you know, requests for name changes of a 2 or 3 year old. And we, you know, in that space, we have an obligation to question where the motivation comes from in that sort of age group. And sometimes it might be that parents are deceased, the child's been in care since they were born, and, you know, it makes perfect sense that the child would take on legally the name of their guardian. There's Aboriginal children. I don't know of any Aboriginal child directly in my space, so just, you know, keep in mind that this is just my little area. That name changes for Aboriginal children, none of them have been successful, or request to change names for Aboriginal children. And so, you know, I don't know what that space looks like outside of my area. Yeah, so that is a reason why there wouldn't be an immediate name change looking like being appropriate. But yeah, there's, you know, connections, one of them, you know, identity, you might have, you know, siblings, so they might have, say, a kinship situation where you've got a biological cousin of your, you know, your children living in a sibling, and they're kind of siblings. It might be, you know, very appropriate for that child to then take on, you know, that cousin or their aunt or uncle's name. So there's some real obvious situations, but there are other ones that we look at case by case, and we do an assessment, we consult, and we get approval that way, or not approved depending on the situation. Yeah. Was there any other questions before I shoot on to the ending of the phase 2?
Yeah, there was one around, does the child rep have to refer to the child by their birth surname? We have a carer here that the child's surname is triggering for her, so.
Yeah, so when I mentioned before around the child reps, it's quite independent, the child rep from Legal Services Commission, so I'm not part of those interviews. But what I do know is that they'll say, you know, what is your name? And they won't say, oh, look, I've got so-and-so's name on, that's different to what you've told me. They won't do that. And so, no, they will go on what the child associates their name to be. What's talked about in the court space, I guess, you know, whether that's appropriate for the years of the child is case-by-case situation.
Great,
Yeah.
thanks so much. And
they won't outwardly refer to the child from their name that may trigger. And we would probably have, more than likely, if we're aware of that, we would already have that in their care plan that the child rep would have.
Great. And then we've just got another carer asking, what about the first name? If it's a long name, not pronounced as spelt, and the child prefers a shortened version.
Yep. So, yep, there is one going through for that exact reason at the moment. Phonetically, it's very short, but when you look at the name, you go, oh, I wonder how you pronounce that. Yes, same process. It's a legal name change, whether it's first or last name.
Great, thank you.
So I guess I'll get, like I said, if there are any other questions, we can always go back or directly have a chat, that's fine. But I'll take you to the point of, at the end of the report now, if thumbs up, are we happy to sort of move on to the court space? So once we've fine-tuned the assessment report, so we will end up having the documents of, we'll have an assessment report, we will have a draft long-term care plan, which we will develop in consultation with you, birth parents, if it's appropriate, and the office. We quite often do that administrative task on behalf of the office for them, given that we've done the assessment, we know most of the context. So where we will, and an ACES tool, so if there's a cultural tool appropriate to that child, or cultural maintenance plan, those 3 documents will be sent up to our executive director for approval to proceed to court if it's recommended for LTG. And with the memo. So the memo is signed, so we give them a summary of what we're working with, we give them the documents, they have a read through, if they're you know, happy with the content, then they will approve to proceed to court. Once that's done, once we've received that approval, we get all the final documents signed off. So what we need signed off is the care plan, because that care plan is the combination of the caring elements of the child for their life domain, but also half of the initial half of the document is actually a court report, which summarises our rationale that LTG is appropriate for this child or children. Once we've got that signed off by the prospective guardians and the carer and the office, we then send that document with the child's birth certificate and their original long-term order and any cultural maintenance plan in a package to Crown. So our Crown solicitor will then have hold of that package. We'll make sure that all the elements are required to go to court. When everyone's happy with that, Crown solicitor will be, the allocated Crown solicitor will then file those documents to the Adelaide Youth Court. And at that point in time, they will get the first hearing date and time. And we will be sent that sealed package of documents. We or the office, whoever's taken on responsibility, it depends whether it's country or, but 9 times out of 10, we will follow through with the court process. We will serve the parties to the proceedings for the first hearing is DCP and the birth parents. So the initial service of documents goes to the birth parents. So one to the father and one sealed document pack to the mother. And they are informed of the pending court hearing. So until the second hearing, the proposed or prospective guardian is not parties to the proceeding until at least the second hearing. So you will not be served the sealed documents until the court adds you to the proceedings. So it gets a little bit legal here, but it'll be really simple as we go through. So we'll maintain a lot of conversations between us or your assessor and yourselves as the guardians. You know, we'll let you know how things are going in the court space, and keep you up to date as much as we know. So when we serve those documents, we then provide Crown with a basically declaration that it's been served, and we attend court, first court hearing. Amongst the COVID situation, we haven't been attending in person. We have been, most of us, linked with by phone. or if it's a country location, it might be a video link between another court and the Adelaide Youth Court. So once that first hearing occurs, if the parents attend either by phone or in person, they will discuss their views, whether they consent or whether they oppose the order. They may have a conversation about that. 9 times out of 10, whilst it's moving through in that space, we don't have any complications. The judge or magistrate is happy with the process and what's in the best interest for the child, and will then progress to they'll add the proposed guardians to the proceedings, and then they will put another hearing date forward. At that point in time, we can then serve the prospective guardians with the sealed court files, and then they are invited to attend the second hearing, either by phone or in person, depending on what's appropriate at this point in time. I would say the vast majority of our cases or applications that we present to court are finalised at the second hearing, and we're done. Celebrations all round, and we get the order, a week or 2 later, we send that through to you. You get a copy of the order. There was a question around ID cards. Someone said that, do they get an LTG like a guardian card? Yes, you do. As soon as an order's granted, we basically put a request into our printer to get an LTG or a guardian card, and that gets sent out to you. So yeah, that's when things go perfectly well. There's all sorts of things that can happen in between that though. I think like I said, 2.5 years that I've been around, I think we've probably had 2 out of 150 plus applications that have gone to trial. The trials haven't been long-winded, maybe 1 extra session in court, so 1 extra hearing or maybe 2. But the vast majority go through without any complications. And to date, I can't say never know, but to date, that's been my experience. What else can I talk about in terms of court? Is there any specific questions, Isabella, that I haven't answered yet?
Yeah, there was one just going back a little bit with the information sent to the birth parents. A carer is asking, can you confirm what is sent in the pack to the birth parents? And then another carer said, what do the birth parents get? A summary of the assessment. And then is there any safety and confidentiality around our personal info being sent to the bio parents?
Yeah. Okay, so like I said before, we send to Crown the long-term care plan, the original order, birth certificate, and cultural maintenance plan. If there is a cultural maintenance plan, we heavily redact it. So there's no, and it is, the cultural maintenance plan is about the birth family anyway. So if there's any other information in there that's personal or sensitive, we'll redact that information because it might be a cultural plan of paternity or maternal side of the family that the other side of the birth family may not know about. So we're very careful around taking out sensitive information in there. The care plan itself, like I said, is half-court report, which is a summary of our rationale. We take out any identifying factors like the name of the school that the child's going to. We withhold the addresses of the majority of our guardians and children, and sometimes birth family as well, particularly if there's a history of domestic violence within the sort of parent relationship. One thing we can't redact though or withhold is names. So a guardian's name will be on the care plan. We can take off date of birth, we can take off address, but we can't take off name. So just be well aware of that. In terms of what was the other part of the question, Isabella, was there another element? so we redact in, so there's identifying features are taken out. It's very summary in context. And yeah, so there's no outward identifying features, and you'll get a copy, you'll get the copy of the care plan and summary of the report before it goes to court anyway, so you'll know exactly what's in there before the parents do.
Great, I think that answers the questions perfectly. There was another one that's relating a bit more to when the carers are in court, so I think you said the second hearing. It's how is the carer's voice heard during the court proceedings? Are there submission documents, or are they invited to stand and voice it to the judge during the hearing?
Yeah, so we will, if you want to address the court, we can let our Crown Solicitor know that, and that they can facilitate any statements that their guardians or proposed prospective guardians want to say in court. Yeah, so the actual document itself that goes to court has got guardians' views. So if there's any submissions that you want to put in terms of from your perspective, you can pop it in under your views in the long-term care plan. If there's anything verbal that you want to discuss in the court or raise in the court, then we can put that through our Crown Solicitor. So it's not uncommon for a magistrate to ask a couple of questions within the court space about, you know, you as guardians and the children. So sometimes there is an opportunity, even informally, to have a little chat with the magistrate. Sometimes birth parents will be invited or allowed to go to the second hearing. Sometimes they're dismissed at the end of first hearing, particularly if they're, you know, have said that, you know, they oppose and, you know, that they've had their say, and they may say, I don't want to be partaking in any other part of the court processes. The court may excuse them for future hearings, or they may be in attendance, case by case situation. But if you've got any concerns about that, obviously we can raise that through Crown, and they can manage that in that court space.
Great, thanks so much, Deanna.
No problems. I think one thing that's come to my attention in the last, you know, several months with the COVID situation is that if you are having a phone link with the court, and you have other family members in your living room or whatever, let the court know who's in attendance. Let the court know if the children are there, because if the court is not aware and they go into some, you know, sometimes it might be that a parent, most recently a parent got quite emotive and frustrated, you know, in the court space, and the court actually weren't told them that the child was actually in the room with the guardian. It was an older child, so, you know, I don't know what the, you know, the entire impact of that was, but, you know, the child could hear you know, the points raised by the parent, and, you know, it may not have been great for the child to hear. So, but the court were not aware that the child was there, so couldn't stamp out that conversation at that point in time, or ask the carer to remove the child from the situation. So if what I can say is that if you are on a telephone link, make sure that you inform the court exactly who is in that room. Any other questions in that space? Isabella?
Yeah, there was one that's saying, after LTG is granted, do the carers receive the birth certificate of the child? And do we receive their files from DCP? Yeah, so the entire file would need to be, you know, obviously obtained through Freedom of Information. So that is certainly not my area of expertise, but it could be obtained through Freedom of Information. You will certainly be provided with, you know, any that you haven't got already, birth certificate, passport, you know, all those sorts of things, which I'm sure you would have a few of those documents anyway.
So yeah, you will be given those, and then anything else could be requested through freedom of information, and that has a completely separate process.
Great.
Yeah.
There was another one that, or a few are coming through, Deanna. I hope that's okay.
Yeah.
The first one is children under guardianship are now assessing additional childcare subsidy, child wellbeing to cover gaps in childcare fees that DCP used to pay, I think it says. Does this continue under LTG?
So a lot of the finances, accessibility to programs and grants, and from guardianship of the CE over to guardianship of their approved carer. So they will have access to Dame Roma Mitchell grants, education grants within that space, and there's several others which are identified obviously and stated in the care plan. First, the ambulance cover, a healthcare card, and all those sorts of things. So when there's eligibility criteria involved, the guardian would be then responsible for applying for any subsidies in that space. We as a department, once we hand over guardianship, I do know of a situation where we're obviously having a subsidy for childcare within the department, and then once it got transferred out to the guardian, then DCP continued to apply for that subsidy. I think sometimes the child was eligible, but sometimes there might be a crossover of whose responsibility it is. Some guardians might go, oh, thanks DCP for doing that for me. Other guardians may say, that's actually my responsibility and it was out of line for the department to just go ahead and do that. So yeah, whatever the eligibility criteria is, if it's just remember that as a guardian, you are legally responsible for all of those, applications and review in that space. But, a bit of communication from both parties always tends to alleviate any miscommunication in that space. So does that, yeah, so the eligibility crosses over into LTG. And all of that information is in the brochure if you want to spend more time reading through.
Right, thanks so much, Deanna. The second question from that carer says, as a sole guardian, if a second non-partner guardian is added, do they have to agree with all the parenting decisions made?
I would, yeah, so from what I'm thinking of is it would be this situation of any parent group, any two people, they parent together, they co-parent, they have some disagreements in that space in terms of, what one parent might agree with the other, and sometimes there's a bit of conflict. So look, I think at the end of the day, the care plan and the expectations that the children's needs are met is a fundamental part of LTG. How you parent is up to you. I 100% confident in our space that we are sure that even if you have disagreements in your ways of parenting, that you unpack that in a healthy manner, and find a space where you can move forward in your parenting together. I think it comes down to if you've got a new parent coming in, so if you've got a sole guardian who commences or has established a new relationship, then as the primary guardian, there would be an expectation that you would only involve someone in that child's life who is, healthy, safe, positive, and everything that you are for that child.
Great, thanks so much, Deanna. This one might be a bit more of a personal one that we could follow up later potentially, but a carer is saying that they've already asked DCP about obtaining the child's files, and they said no. They will only release it when they're 18. So
Yeah.
this is maybe something we can follow up later.
Yeah, absolutely. Yeah, and possibly through that pathway of freedom of information. But yeah, I can certainly take that on notice and find out a little bit more about that.
Great. We can. I can send you the details after regarding that one.
That sounds great.
And the last one here was, can guardians' names be added alongside the child's biological parents on the birth certificate?
I don't know any instances that has occurred. So I, again, would have to take that on notice. Yeah, I guess, yeah, I don't know. I would say not, given that it's not birth relative, but I don't actually know the legalities around that. So again, pop that on the car park, Isabella, and I can chase that up.
Yeah, perfect. I will do that.
Just on birth certificates, just keep in mind that with the name change processes, obviously, if you go through at the time of the court space, that the court application will be in the child's birth name, and that the order will be in the birth name, and it takes between 6 to 8 weeks for birth deaths and marriages to formalise either a change of name certificate or supersede their original birth certificate with a new one, which has their new name and refers to their birth name on the back of that document. So, and equally, you know, have a conversation in phase 1 or even prior to phase 1 when you're in your annual reviews or a forum like that, is to have a think about the purposes of a name change. Sometimes name changes occur due to safety reasons for the children. And again, in those circumstances, you might want to wait until after the order's granted. However, knowing that all the formal documents that go to court actually do have the guardian's name on it. So that can be a little bit tricky if there's some significant care, like safety concerns in that space. So sometimes, I mean, that might be one of the reasons why a name change may not be appropriate or safe for the child. So, or LTG for that matter. We've had one case that I'm aware of to date where the safety risks are significantly high, that, you know, at this point in time, long-term guardianship with the approved carer is not being you know, followed up for those reasons, where we just you know, the name, the safety, the knowing carer's name, you know, can be tricky in that space. So have a think about the long-term as well as short-term implications of a name change and which process you are going to participate in. I think another question has come in, Isabella, around completing the application.
Yeah, it says, once a completed LTG application has been sent from your team to the Crown, can you explain the process that happens when birth parents are contesting the order? Is this initially managed between the solicitors and birth parents? If so, how is this managed?
Yeah, so that is completely out of my area. It is managed through all the legal parties. So, for example, I mean, I know from our space in terms of the hearing procedure, you know, it might go to, you know, you might have a first hearing, you might have mediation, you might have an adjournment for some further work to be done, and then you might have another hearing. You might have a pre-trial conference, which, you know, talks about where legal parties come together and talks about, you know, a trial. I'm not a lawyer, so I don't know the intricacies of that space. If it does go to trial, it potentially, like any other DCP process, particularly, you know, 12-month orders, 18-year orders, you know, that is probably a little bit more common in that space to go to trial. But certainly in my space, it's not as common. The legislation, though, does require a birth parent to bring new evidence to, you know, the court as to, you know, why. Sometimes it might be just around, you know, sometimes it might be, this is an opportunity to have my child back, so I'm going to push to have my child back. And if that's the case, you know, obviously well, in every case I know of, it's dismissed due to the fact that, you know, the carers have had the child in their care for so long, and it is child focused, and it might be just more around the contact stuff. So you know, to maintain some connection with family. But the onus is on the parents to bring new evidence to the court, to us, you know, to actually participate in any conversations around the future, you know, movements, you know, in terms of court orders for the child. So like I said, you know, the majority, or the two little trials that we've had in our space didn't last long, because the court in those two circumstances said that, you know, no new information's been brought forward to the court, and therefore, you know, I'm not going to entertain further conversations around this. So if it does, so trial will take as long as it takes for the magistrate to be confident that LTG is the answer. So yeah, and like I said, I'm yet to have one order in the last 2.5 years that hasn't gone through to date, you know, so I don't know what the future holds. But, you know, the legislation does say that any birth parent that brings arguments to the court, you know, really needs to have, a lot of evidence to suggest that this wouldn't be the right thing for the child. And I don't know of one that's, you know, that's been successful in that space. I can only talk from my experience. Yeah,
just adding on to that, how about once LTG is granted, is there still scope for the parents to have the order revoked? This was one of the questions that was sent through yesterday.
Yeah.
That a carer personally, the child's birth parents are contesting their application, and they were hoping to have some reassurance once that goes through. If there is or isn't any legal avenues where that can be challenged, or is it final?
The application to court would come from the parents in that circumstance, so they would have to get legal representation. The legislation does enable them to go back to court and request to vary or revoke the order. I don't know of one that's occurred. So I can't tell you an outcome of one of those processes. Because it's not occurred in my space. So they can go back to court, they can request a revocation of the order. But again, the onus is on them. And then, you know, DCP are no longer parties to the proceedings, but we may be called upon from the court as an interested party, to provide, you know, documentation, evidence, reports that we've previously had, obviously for other court matters, that, you know, would concrete the reason why LTG shouldn't be changed.
Right, that's,
yeah.
Thanks, Deanna.
But it is one of those things that the provisions are there for it to occur. All right, so I think once, I think I've covered the court's process in terms of, you know, once the application's put in, we get this sealed documents, they get sent through to the birth parents firsthand. Once the carers have been added to the parties to the proceedings, they then get served the filed documents, sealed documents, and then we proceed to court. Once the second court hearing or subsequent, whichever point it is finalised, the matter is finalised, excuse me, We tie up loose ends from our end. We inform carer payments that the order's gone through. We make sure that the new order is popped up on our case management system, and the family, so yourselves as the guardians and the children, right off into the sunset. And we basically only stay open for administrative purposes, for financial review and carer payments. Other than that, no ongoing case management occurs.
Another question just popped up regarding the birth parents contesting. So it says, if the birth parents contest after LTG has been granted, do the LTG parents have to bear the cost of contesting against the birth parents?
The general rule expectation would be it would be at the cost of the guardians. Yeah. So, yes, if they were asked to go to court, they would have to represent themselves.
Great,
Yeah.
thanks.
Yeah, so whether or not there's other potential for DCP to be involved, that would have to be identified through executive. I don't know, because we are no longer parties to the application or the order once it's gone through. So we don't have any legal standing in that space, and Crown solicitors wouldn't be involved.
There was just another one regarding the very early stage. A carer was just wondering who provides us with the initial paperwork, or can we access it online?
The initial application?
Yeah.
Yeah, absolutely, that's online. So you can go into the DCP website, and I think I did send you that link, Isabella. Yeah. So you can, yeah, they're all public links, so I'm more than happy for you to share them. So you would get the application form, or just ask your allocated worker to flick you one out, or write it together and submit it on your behalf. There's lots of different ways.
Great.
Yeah.
And just another one regarding the the court processes.
Yeah.
A carer was advised recently that an application to change order is sent from Crown to LTG and DCP. Can you explain what this document is and what it entails? And then she said, as Crown sent it for DCP and LTG to review and send back.
Yeah, okay. So when we have all of our final documents at the end of phase 2, we have our care plan, you know, all the other documents that I was talking about, birth certificate, initial order, and we submit that with a letter of instruction. So our letter of instruction instructs our Crown to follow up on an order that we've got on that instruction. So what Crown, once Crown allocates a solicitor, the solicitor will then put a draft application together for us as the department to double check that it's accurate, because we are their clients. So they basically pull together a template with all the information, so child's names, parents' names, prospective guardians' names, what orders we're seeking, and then we double check it for accuracy. So they do send it to us and they say, is this accurate? We send back, yes, looks perfect, because it's basically saying what our letter of instruction said, and then they send that into court. They file that with the other documents, and so when that filed pack is stamped through the court, they then send us the application, care plan, you know, and the associated documents in a pack, and that's what's served out. So I think that answers your question.
I'll just check. Does that answer your question? I think it was, yep, nodding, perfect. There's another question here. I think you may have answered this earlier on, but is there any way to speed up the process of phase 1? We are really at the mercy of the current office completing what needs to be done. Would there be a fair time frame to expect them to have it completed? So the phase 1 stage.
Yeah, case by case, it does depend, because sometimes there's a lot of little intricacies that need to be ironed out and understood in that space. You know, contacting parents and things like that. I keep a list of all the applications that come through to the inbox. So long-term guardianship at sa.gov.au. I keep record of all the applications that come in. I do and obviously I let the office know, like I said before, that there's a phase 1 required. If I haven't heard anything within 3 months, as in if I haven't received a referral for phase 2, I chase up the office and I say, hey, you know, what's happening there? Or I look on my system and see if things are in progress. If it has stalled a little bit in that space, I push a little bit gently from my side of things, and, you know, a couple of emails, a couple of phone calls, and make sure that they are, you know, obviously, you know, not having any struggles that I can help out with from my perspective, or any advice I can give. Sometimes, particularly in country areas, it's really tough to get a PSW or a PAC, a Principal Aboriginal Consultant, or a Principal Social Worker out to an office or available for consultation. So sometimes that can draw out a little bit. But I would have thought, you know, 3 to 6 months isn't completely unrealistic. If it's a really simple, and I say simple tongue-in-cheek, but if there's no big complications, then and all of the case management side of things is up to date, then we would expect to get a referral, you know, shortly after a phase 1 has commenced. So I would have thought, you know, a six months or so would be, you know, the maximum where I actually start, you know, probably pushing a little bit harder for a process to be undertaken or completed from that space. The other thing is too that, you know, you have a right to, you know, obviously I would advise to go through your allocated worker first on all occasions. But if you're not getting a service through that pathway, then you can escalate it, you know, appropriately, whether it's through their supervisor or the office manager. And then obviously the department does have some complaints avenues as well. So, you know, you're well within your right to follow those processes, should you feel like you're not being provided with an appropriate service.
I think one of the carers is asking, it's very difficult when your child is unallocated to get anything done.
Yes.
I might get her to clarify that a little bit more, because I'm not sure exactly what she's asking, but
sometimes children aren't allocated to a worker in the office space, so that can certainly put on a hold in terms of the phase 1. Yeah. Yeah. So yeah, and that's what I was saying before around, you know, when I will gently push from my space, I escalate it from my space in out-of-home care when things haven't moved, you know, at a reasonable pace. And then obviously we've got some of the other avenues that we can, you know, either yourselves as independent parties can contact through DCP and myself, and case consultation, and, you know, direct conversations with some of the other, you know, consultation sort of stakeholders, and see if we can get some movement. But yes, resources, you know, it's one of those things departmentally where it's a real reality in our space, that sometimes we're resource poor, and, you know, there are limited options around that. But given if it's discussed, it's more likely to stay on the agenda.
great, thanks so much. Another question's just come through saying, can you please explain what is to expect from start to finish about the day of court? If going in person to the youth court, where do we go? What can we expect it to look like? And how is the hearing run? Who attends it? Yeah,
so is that someone wanting to know if we can be more clear about that at the start of a process? Is that what they're asking for? Or
yeah, I guess maybe the day that they're going into court, so when the carers are going into court, what that day looks like?
Yeah, so we won't know. Yeah, we can absolutely talk about that in that space. It certainly is case by case. I mean, if we spoke to people a year ago and said that you won't be attending in person because there's going to be a random virus, you know, that can be a bit tricky. But obviously, we can talk about what the general expectations are within the court space. And yeah, and I can make sure that, you know, in our next team meeting with my assessors, that we have a conversation around that to make sure that, you know, those things are unpacked. But I think in the early days of an assessment, like someone rightly mentioned earlier today under the chat, is that there is a lot of information to take on board. And I think, you know, talking about everything, including, you know, that what could happen in court, what might happen, what might not happen, that's a lot to take in an early conversation, as well as doing your medicals, as well as all the other parts of phase 2. So we could touch on it, I think, but we're also conscious not to overwhelm, you know, families with too much information, because it is really, you know, it's quite a huge process.
Right. Does that answer your question, Kimberly, about the day of court? Not really. I guess with that one, we could possibly follow up, as you said, Deanna, maybe having a chat with your team to see if they can talk about maybe developing a bit more information about what that would look like.
Yeah, and, you know, I'm quite happy to have, you know, following up conversations with Kimberly as well, because we've, you know, obviously, you know, had some conversations. So if there's something that's still not clear, then, you know, absolutely ask the questions. Like I said, we can only go on what we expect to happen in court, which, you know, I've talked about today. You know, on an average day, this is what happens. We go to, you know, parents, DCP go to hearing 1, hearing 2 is the guardian is invited, and then 9 times out of 10 the order's granted in that space. What happens in a trial, I can't really give you any idea about what happens. It's case by case.
Yeah.
I can't really validate that anymore.
Thanks so much, Deanna.
No
there's another question that just came through saying, can you apply for LTG 2 years after you've had the child in your care, or 2 years after they have been under long-term orders? For example, if the child has been in our care for 2 years, but only under long-term guardian orders for 6 months, are we still able to apply?
Yes, big yes. It's the reason that for the 2-year rule, and it isn't a concrete rule, and I'll give you an example of what that might look like in a second, but the 2-year rule is around the department, you know, you having an opportunity to get to know and form a relationship with this child, for us to document and observe and have evidence of what that relationship's, you know, developing like. And so, you know, that's why the 2-year rule is in place. If you had, for example, 2 consecutive 12-month orders, and you've had that child in your care for 2 years, as soon as the long-term order is in place, you can look at doing LTG. So it really is just the evidence around making sure that we actually know what the needs of the child is another, you know, fundamental part of that. So yeah, definitely though, you are eligible as long as you're an approved carer, and that you've had that child in your care for 2 years, and there is an existing long-term order in place at the time you apply, then yes, you can apply. I hope that makes perfect sense.
Does that answer your question? Oh, I can't see her. Yes, but that does answer her question.
Fabulous. Okay. When I mentioned before around the 2-year rule, an example where the 2-year rule would be, you know, considered to be waived might be if you've already got a child in your care for a couple of years, and there's a, say you've got a 3 or 4-year-old in your care, and then there's another sibling that comes into care, and you joins your family unit. We could seek approval from the CE to actually proceed with LTG for that sibling group. And because, you know, we would love to see siblings together. Where we do need, as a department, and yourselves need to be, you know, I guess understanding of is, you know, any new child or new baby that comes into your household, is, do you feel that you know enough about the needs of the child to walk away from the department and feel like you have everything you need to be able to care for this child without departmental support? So you would access all your other networks. But sometimes when our little bubs are young, we don't know what some of the longer term trauma impacts might be, behaviours that might exhibit later on. And so we need to be careful as a care team, yourselves included, that we're not setting you up to fail, even though it looks fantastic at the moment. So we need to be really sensible around that, what that looks like for the child's best interest as well as your own.
Great. I'm also just being mindful of time. We've just hit 12. There's just 2 more questions that have come through.
Yeah.
And I'd also ask if there's any other burning questions that you guys are wanting to be answered today. If not, still feel free to send them through to me through my email, and I can always follow them up for you afterwards. But the next question was, is it correct that once LTG is granted, that we need to take out an order to the family court if we are wanting it recognised interstate, so outside of SA?
Yeah, so with the orders that are granted within the Adelaide Youth Court are for the jurisdiction of South Australia. So if you are moving interstate, then that order would not be recognised in another state. So if you are planning on moving to a different state, you would need to register the order with the Australian Family Court. Keep in mind though that all states besides Western Australia are under the Australian Family Court. Western Australia have their own family court system. So you would need to, if you were anywhere from the, you know, Western Central over to the Eastern States, the Australian Family Court, if it's Western Australia, you would have to register your order with the Western Australian Family Youth Court. No, Family Court. Sorry, too many courts.
Great, thanks, Deanna. And the last question here was, which I think you may have mentioned before, was if you're wanting to add another guardian to the order, do they have to be an approved carer?
They would, the guardian would, the existing guardian would put an application to the Adelaide Youth Court to vary the order. So that is to add a guardian. What happens in that space is that, and again, it hasn't happened very often in my timeline anyway, but what would usually happen in that space is that the court will require some sort of assessment to be able to make a decision. And given that we've been party to the child's life for a big chunk of time, then it's likely that we would be asked to provide some sort of assessment. And that might be, something like we do a phase 2 would constitute a carer approval or for that child. So it might be a specific child only sort of assessment for approval, and then also meet the requirements of the court.
Great, Kay, does that answer your question? Thumbs up? Perfect. And Kimberly, did that answer your question before about the interstate, sort of? I can follow that one up for you as well, Kimberly, if you'd like after, just to get a bit more info.
Yeah,
perfect.
Yeah, it's not something that we do regularly. It's something that I've been recently talking to our DCP legal about, in terms of, because I believe after talking to the family court, it is a requirement for us to send a letter with the order attached to say, please register this within your court space. What that then, my understanding, and again, I'm no legal guru by any stretch, but what would happen is that if a parent went over and, you know, tried to take the child from another state, then federally the order would be recognised.
Kimberly just specified the question a little bit more. She just wanted to clarify how it works if you're going on a holiday. Are we recognised as legal guardians? So, for example, if we had to go to the hospital on a holiday, are we recognised as the legal guardian?
Yeah. So you would be a resident of South Australia still if you're on holidays. So your court order is recognised from the state that you're in. I will double check though, but I will need to seek advice from our DCP legal team around, you know, the intricacies of what that might look like. But really, it's around, from my understanding, it's around recognition of an SA order federally if you are moving. If you are going on a holiday, you still reside in South Australia, so the order is recognised where you live.
Right. How's that, Kim? Is that bit perfect? She's nodding.
Kimberly, I'll double check that though, and make sure that I let Isabella know what the outcome of that conversation is, and why, like the legal grounds, what the rationale is around that, and Isabella can distribute it for me.
Right.
So all carers know.
Thanks so much. That's all the questions for now.
Fantastic. I hope it has been an informative session. I know that there is a lot of information to take on board for good reason. It's a huge process. Let that digest a little bit. And like I said before, you know, you've on the application form is our inbox. That comes directly to me anyway. So if you send any questions or whatever to longtermguardianship@sa.gov.au, I'll be able to respond to that. Otherwise, you know, Isabella, I'll give you, I think you've got our reception number as well, but I will email that to you if in case people want it. The other thing that I've got is just a handout, which is from normally our presentation, our PowerPoint presentation. I have got some little slide handouts, and my details are on that also. So I'll email that to you before the end of the day.
Great, sounds fantastic.
All right. I welcome anyone to give us a ring, even if, or an email, even if you're contemplating LTG, just to unpack any questions or concerns, or, you know, anything that you might want to discuss. You're more than welcome to contact us.
Great, thank you so much, Deanna, for your time today. We all really appreciate it. Can I just ask everyone here today, is everyone feeling okay with what was discussed today? Is there any other burning questions that we could get answered? Everyone's feeling good about it? Great, everyone's nodding.
Overwhelmed with information.
Yes, definitely a lot of information, but it was really good to have you here and clarify a few of those questions. Everyone's just typing thank you in the comments in the group chat, Deanna.
Okay, I see them, they're coming up. Thank you for your time, and I really do hope I give you some clarity, and like I said, give us a buzz anytime we can talk.
Also, just to the carers that are here today, our team here at CFC, we are working on a few carer guides around this topic, so definitely keep an eye out for those as well. But then again, there is a lot of information that is on the DCP website if you're needing further clarification on some stuff. And I will send those through as well to your email addresses, because Deanna did send them through the direct links. But other than that, I think that's everything today.
Fabulous. Thanks everybody, and take care of yourselves.
Bye everyone. Have a great day. See ya.